Welcome to Facts TV News, where everything is true. Rushawn Patterson and co-accused remanded. Rushawn Patterson, the man charged by the police with the murder of popular social media influencer Anika Sekiana Thousand, was remanded in custody when he made an appearance in the St. James Circuit Court on Wednesday. His co-accused, 47-year-old security guard Juan Early Bird Rose, was charged with the offense of misprision of a felony. Although Rose's case is connected to that of Patterson, both men appeared separately in the circuit court and are to return to court on two separate dates. Rose is accused of either being involved in the matter or failing to notify the authorities. During court, Patterson's attorney, Michelle Thomas, made a bail application for her client. A December 15 date was set for the bail application consideration. Similarly, attorney-at-law Martin Thomas made a bail application on behalf of his client Rose. While Thomas wanted the court to immediately hear the application, the Crown was not ready, as it wanted certain information in place first. Martin Thomas argued that his client has been in custody since November 4, has appeared in court on 3 occasions after being charged, and it was made known that a bail application would be made. Thomas, in making his bail application, said his client, who has more than one dependent, has lost his job. At the time he was arrested, he was working as a supervisor at Guardsman, a position which he has held for the past 9 years. He is an ex-soldier. He has since lost his job. He is taking care of a lady who is 75 years old. He has young children, one of whom is 6 years old, who is dependent on him for support, stated Thomas, who noted that lives have been ruined. Thomas said he received statements pertaining to the case and disclosure last week. However, he said 2 statements are remaining. However, the Crown argued that their reason for asking for another date is that the police have been asked to ascertain certain information. For example, where he is living, certain information, my lady, that will inform the Crown as to how to address the application before you as it relates to the conditions of bail, and we will not be able to get that information until the police go to the location and make their checks, told Justice Andrea Thomas. A November 28 date was set for a bail application consideration. Both men were appearing in the circuit court for the first time after their case were transferred from the St. James Parish Court through a voluntary bail of indictment earlier on the same day. Both cases were heard together in the parish court. In giving notice, the Crown argued that it was intent of the Director of Public Prosecution to end the case in the parish court and have it transferred to the circuit court. On November 11, the police had stated that Thousand traveled from Kingston to Montego Bay, where she was picked up by Patterson at approximately 7:30 p.m. on October 20. During the evening, they visited a restaurant in Hanover and a guest house in St. James. At some point during the night, an argument reportedly developed between them, which resulted in Patterson reportedly strangling Thousand and disposing of her body. Thousand's body was fished from the sea in Reading, St. James on October 21. The police, in carrying out their investigation, named Patterson as a person of interest on October 22. He was picked up at a guest house in Hanover by an Air 1 operational team on November 2. Criminal Records Office to be closed on Thursday. The Jamaica Constable Force's Criminal Records Office, CRO, is reminding persons that its pick-up location at the Police Office Club on Hope Road, St. Andrew, will be closed on Thursday, November 22. The CRO says it apologizes for any inconvenience caused. All other locations remain open for regular business hours. JFJ calls for review of use of body-worn cameras by security forces following fatal shooting incident in Kingston. Human rights lobby group Jamaicans for Justice is calling for a review of the use of body-worn cameras by members of the security forces. JFJ's executive director, Michael Jackson, said, when there are altercations between the security forces and members of the public, investigators often rely on video footages produced by residents. Ms. Jackson pointed to the fatal shooting of 24-year-old Teron Hewitt by a member of the Jamaica Defense Force at a security checkpoint in central Kingston on Monday, November 21. Ms. Jackson noted that if the government is serious about improving its human rights record, the necessary steps must be taken to ensure that members of the security forces are held to a high standard and act with transparency and accountability.
This also allows both body-worn cameras and social interventions to occur. We have not heard anything from the government beyond recently they announced the monetary support in totality that is being provided to the Zozo communities. We are not assured how much of that money is going to specific social interventions. We have not gotten any quantifiable indicators to suggest that X amount of persons have been trained, X amount of persons have been deterred from a life of crime. So there is no verifiable information to suggest that the ZOZO is working. On the matter of the body cameras, how we know of these instances of abuse or altercations with citizens is when the brave men and women within these poor and marginalized communities stand up and record these altercations. And it is important to note that had the JDF officers been utilizing body-worn cameras, perhaps we would have been more assured that they would be acting within the confines of the law. But certainly that is not what we have been seeing. We have to be relying on citizens to pull out a cell phone and record. So the government ought to do better. They have to review whether or not those are working based on the intent or the objective that they announced.
Jamaicans for Justice urges Senate to prevent extension of states of emergency. Human rights lobby group Jamaicans for Justice JFG is urging the Senate to take the necessary steps to prevent the extension of the states of emergency now in effect in several police divisions. The appeal follows the passage of a resolution by the government in the lower house on November 22nd to extend the SOEs until January 14 next year. The opposition did not support the resolution in the lower house. The resolution will next go to Senate, where at least one member of the opposition must vote in favor to effect the extension. In urging opposition senators not to support the move, JFJ Executive Director Michael Jackson pointed to certain of the regulations governing the SOEs.
We made note that the regulations were in fact made public. We actually received it from media outlets Thursday evening, which is 2 days after the SOE was declared. Firstly, if persons are already detained under the current SOE, we do not know the composition or the registry of the review tribunal. Therefore, people have no opportunity to make an objection to their current detention. That flies in the face of the Constitution and the guarantee that it provides to a fair and impartial hearing. Outside of several other areas of concern with the regulations that may violate one constitutional right to freedom of movement, not to self-incriminate. For example, we also saw another glaring issue with the retention of your fingerprint and other biometric data under the DNA Evidence Act. Though it is referenced in the regulation, the ability of the government to retain your data for an extended period of time without you ever being charged is clearly a violation of one's constitutional rights. Even outside of the regulation, from a JJ perspective, the SOE in and of itself is unconstitutional and unlawful in how it is currently being utilized by the government. Government senators, we're urging them, vote on conscience and in the public's interest, not along party lines. To the opposition, we're asking them to fulfill their parliamentary role, that to oppose bad policies that the government may be putting forward is a constitutional requirement of their function. And we're urging the opposition not to succumb to political pressure and to ensure that they vote again on principle and along the public's interest. That is what we're asking the Senate to do when they meet next to discuss the extension of the SOE.
Government MPs use majority numbers to pass resolutions seeking extension of SOEs. Resolution to next go before Senate. Despite no votes by the opposition, the government was successful in its bid to pass a resolution seeking to extend the state of public emergency in several police divisions until January 14 next year. This as the majority count of 44 government members of parliament voted in favor of the resolution. There were 4 no votes and 16 members were absent. Prior to the vote, Prime Minister Andrew Holness appealed to members of the opposition to support the security measure, pointing out that it works. He sought to respond to the debunk many of the concerns raised by the opposition, including an over-reliance on SOEs, constitutional violations, and breach of rights. Mr. Holness stressed that in light of the spike in crime and violence, the government must respond using all strategies available in a bid to save lives. He likened the crime solution to being a public health epidemic.
Taking life could now be described as a common practice, especially when you have over 1,000 murders yearly in our social, domestic, economic, and intimate partner affairs. And this is without us being at war. Taking life is now at epidemic levels. If 1,000 or more persons were dying from a disease in Jamaica, we would say we have a public health crisis. We would have initiated quarantine procedures, that is, detaining the suspected carrier of the infectious disease. All effort would be made to isolate the infected person. There would be no argument about human rights and civil rights, but violence is such a disease that is infecting our society, and the more virulent form of it is violence that leads to murder. Murder is a public health crisis in this country.
In response, opposition leader Mark Golding said he cannot support the request for an extension and again criticized the government for the manner in which it is handling the problem. He also chastised the government for not having dialogue with the opposition about the concerns raised, which did not augur well for seeking bipartisan support. Golding noted that even with amendments made in the wake of the court ruling, the new regulations tabled for the current SOE still have several issues.
Firstly, the SOE tribunal's powers under paragraph 38(12) is to make findings requiring the competent authority to give directions as to whether to preserve, vary, or revoke detention orders. But if someone is detained under paragraph 33 of those regulations, there is no detention order. Paragraph 33 does not provide for detention orders. This means that paragraph 38(12) is, in my view, defective as a procedural safeguard in the case of detentions under paragraph 33. Secondly, if the tribunal rules in favor of preserving the detention, a person detained under paragraph 33 does not appear to have access to the court under the regulations for the entire remaining duration of the SOE. Once the tribunal has ruled, access to the court is not provided. Thirdly, if a person is detained, who determines whether his or her detention is under paragraph 33 or the other detention provision, which is paragraph 30, subsection 1? Two separate and quite different legal regimes are triggered. It is not clear how you know as a detainee which procedure you must follow.
Please remember to subscribe, like, share, and click the notification